Hello, friends! The rumors are true. Florida Governor Ron DeSantis has recently signed a new alimony law. For those of you that have heard, the new alimony law went into effect in early July of 2023, and there are some big changes to the Florida alimony law, and we're going to cover them in today's video. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. There have been several attempts to modify the Florida alimony statute over the course of the last couple of years. It actually was vetoed by the previous governor, and last year the current governor of the state of Florida vetoed the bill. So when the bill finally passed the Florida Congress and was signed by Governor DeSantis, there was an outcry for those of the groups that were against the changing or revisions of the alimony statute. For example, the First Wives Advocacy Group, and then there were some people who were actually happy about the modification of the alimony statute. So we're going to get into the biggest changes in the Florida alimony statute, starting with the biggest one of them all, and that is the elimination of permanent alimony. That's right, the new Florida statute eliminates permanent alimony. Instead, the new Florida statute sets up 4 different types of alimony. So under the revised Florida alimony statute, which is 61.08, it specifically says that in a proceeding for dissolution of marriage, the court may grant alimony to either party in the form or forms, meaning multiple, of the following, and it is only temporary, bridge the gap, rehabilitative, or durational alimony. No more permanent alimony. As you can see, it is out. Now let's talk about it. Temporary alimony is exactly what it says. It's from the filing of the case until the divorce judgment is entered. It is alimony that is given to one of the spouses during the pendency of the divorce proceedings. It usually ends after a final judgment is entered. The second type of alimony that is still good is bridge the gap alimony, which is a type of alimony that assists a party with a legitimate, identifiable short-term need. The length of an award of bridge the gap alimony can be no longer than 2 years. Next up is rehabilitative alimony, which may be awarded to assist a party in establishing the capacity of self-support through either redevelopment of previous skills or credentials. So let's say they needed to get their vocational skills updated or back. Or number 2, the acquisition of education, training, or some sort of other appropriate employment skills or credentials. So they have to go back to school or whatnot. And the 4th alimony that is listed is durational alimony. Durational alimony may be awarded to a party to provide a party with economic assistance for a set period of time. Before we move on to the newer parts of the statute or what has changed, we also have to note that remember that alimony is only awarded when the court deems equitable, and in an award of alimony, the court can either award it in periodic payments, which means like monthly or quarterly, or it can award it in the form of a lump sum payment. So keep that in mind. All right, so the second major change in the alimony statute is a lot of times if there's an award of alimony, it used to be that you would try to secure that award with a life insurance policy, or you'd force the person who is paying alimony to get a life insurance policy, so in case something happens to them, they pass away, they're able to pay off their alimony obligation upon death. Well, the statute has changed. It now says that if a court orders a party to purchase or maintain a life insurance policy or bond, the court may apportion the cost of such insurance or bond to either. It used to be the obligor, or the person who was paying. Now it is to either, and now it is based upon a determination of the ability of either party to pay. So the court has to make an extra determination, which is something new with respect to the life insurance policies, securing the benefit to make sure that that is paid off. Another huge change is that the court changed the length of time for the different terms of the marriage. In other words, the statute 61.08 now reads that for purposes of determining alimony, there is a rebuttable presumption that a short-term marriage is a marriage having a duration of less than 10 years. So before, short-term marriages used to be 7 years. Now the legislature has expanded it 3 more years. Moderate-term marriages are marriages that have a duration of between 10 and 20 years. It used to be moderate term marriages were between 7 and 17. And finally, a long-term marriage is a marriage having a duration of 20 years or longer. So before, a long-term marriage was defined as 17 years or longer. Now the legislature has increased it for 3 years. That's huge. Now, narrowing on to the different types of alimony, as I mentioned previously, the rehabilitative alimony has been capped. Yes, that's right. The length of the amount of the rehabilitative alimony award cannot exceed 5 years. So that's something new. So the most significant changes occurred in the durational alimony concepts in Florida Statute 61.8. So the durational alimony component of the statute has seen various changes, and we're going to try to review those now. Starting with the statute reads, durational alimony may not be awarded to a marriage lasting less than 3 years. So if you've been married less than 3 years, no durational alimony for you. Second, how long the person paying alimony has to pay. The statute sets forth different percentages. So an award of durational alimony may not exceed 50% of the length of a short-term marriage. So if you're in a short-term marriage that's 8 years, the longest that you can get of alimony is 4 years. In a moderate-term marriage, it can only be 60% of the length. And in a long-term marriage, it can only be 75% of the length of the marriage. And that is the biggest impact, because before there used to be permanent alimony. Now, if you're married, let's say you're married 29, 30 years, the length of alimony is about 21 years, which is 75% of the length of the marriage. And that is huge. And it's going to be interesting to see if anyone takes that up on appeal. Very interesting. Up next, the statute specifies when it is that a court may extend durational alimony. There's always a loophole. Let's see what it says. It says under exceptional circumstances, the court may extend the term of durational alimony. And then it gives you several factors. The first of which is applying the economical factors that we'll talk about in a little bit. But it also considers the age and employability and the limited age and employability of the person receiving alimony. In addition to this, it will consider whether the person receiving alimony has available financial resources, or if there's limited financial resources for him or her to self-support themselves. Another one that I like is if the person receiving alimony is mentally or physically disabled, that renders or will render them unable to be self-supported. That is a very interesting loophole, because that one in particular, if at some point the person who is receiving alimony has some sort of debilitating illness, some sort of long-term illness, there may be exceptions to extending durational alimony, even though the statute says that you can't do it past a certain percentage. Now, the fourth factor that the court will consider is the extent to which the person receiving alimony, or the obligee, is a caregiver to a mentally or physically disabled child, whether or not that child is an adult, and as long as the child is a child that is in common of the two parties and still under the care of the person who receives the alimony. What's interesting is that if that type of alimony gets extended, it will terminate upon death of the child. All right, the next big change has to do with the amount. The amount was always a fight. Here in Florida, the amount used to vary between 45%, sometimes even more if they signed a bad deal, to about 40 or 35% of the party's net income. Well, the new and amended Florida statute settles it. According to the amended 61.08, the amount of durational alimony is the amount determined to be the obligee, which is the person receiving income, their reasonable need, or an amount not to exceed 35% of the difference between the parties' net incomes, whichever amount is less. So let's work through this. As an example, let's say husband makes $150,000 a year, wife makes $50,000 a year. Let's pretend for purposes of the example that both of these amounts are net income. Husband's net income minus wife's net income is $100,000 net. So the durational alimony award cannot exceed 35% of that net income. So let's say in our example it would be $35,000 a year, which comes out to more or less $3,000 a month would be the wife's alimony award, unless her need was less. So let's say she was able to cover most of her expenses and her need was really $2,500 or $2,000, then she would get the difference, or the lower of the two. That's kind of in a nutshell how it's determined. But what is the most interesting part is that there never used to be a statutory cap. The other thing that the new statute says is that net income shall be calculated in conformity with Florida statute 61.30, which is the child support statute that I mentioned before. before, and it is a very interesting list of what is considered income, which we'll review at some future time. The other big new nugget of the alimony award is that the award of alimony may not leave the payor spouse, which is the person paying the alimony, with significantly less net income than the net income of the recipient unless there are exceptional circumstances, and this is going to be a big fight moving forward. So interesting stuff. All right, so now that we've discussed some of the big ticket items as to what has changed under the Florida statute for alimony 61.08, let's talk about the process or the procedure. The first step, as it's always been, is need versus ability to pay. The court shall first make a specific factual determination as to whether or not the party seeking alimony has an actual need for alimony and whether the other person has the present ability to pay alimony. The burden is on the party seeking alimony. The court must make written findings supporting a denial or an award of alimony. But a little bit something that's new is that the court also has to make a written findings as to the lack of need or lack of ability to pay alimony if that's what occurs in a particular case. Once a court determines that there is a need by the person who is seeking alimony and the ability to pay by the other spouse, then the next step is for the court to determine the proper form of alimony. So there are 8 factors, the first of which is the duration of the marriage. And this factor used to be in the old statute, but now it's the first factor, whereas before it used to be the second factor. Next up is the standard of living established during the party's marriage. That used to be the first factor before. It is now the second factor. And what's interesting is there's a new language to it, which says the anticipated needs and necessities of life for each party after the final judgment. So that's a new factor. When they say the standard of living, they talk about were they living in a big luxurious house, were they just getting by on their bills, what kind of cars did they drive, were they going on vacation, things of that nature. The next factor that the court will consider is the age, physical, mental, and emotional condition of each party. What's new in this particular statute is it includes an analysis of whether either party is physically or mentally disabled, and that the resulting impact of this physical or mental disability has. The court also will consider whether or not these conditions are permanent or temporary. So this is something new, and this is something that I actually really like about the statute because it contemplates both mental and physical disorders. The next factor is the earning capacities, educational levels, vocational skills, and employability of both parties, including the ability of either party to obtain the necessary skills or education to become self-supporting. What's interesting is that it adds language, including the ability of either party to obtain these skills at the time that the alimony award terminates. So that's a little bit of a tweak in that particular factor of the statute. The next factor is the contributions of each party to the marriage, including but not limited to services such as housekeeping, childcare, education, and support for the career building of the other spouse. The next factor the court will consider is the responsibilities each party will have with regard to any minor children. What's new about the language, it will give special consideration to the care and maintenance of children that have either a mental or physical disability. So I think that's a great update to the statute as well. The final factor that the court will consider is any other factor necessary for equity and justice between the parties. What's very interesting is it specifically mentions that this may include a finding of a supportive relationship as provided for in Florida Statute 61.14. We did a whole video on supportive relationships, so check it out. But it's fascinating to me that it sits there and it spells it out in the new amended alimony statute. So interesting stuff. Also, as a side note, the one factor that was in the old statute that is now out is that the court used to consider whether or not the alimony was taxable to the person receiving alimony and tax deductible to the person who is paying alimony. That part is no longer in effect. And finally, the other big piece of news is that the amended alimony statute says that it's any case either filed after the effective date or any case that's currently pending. And that is huge because some people have cases pending and it affected what they might have asked for initially in their divorce petition. conditions. So that's a very interesting note, because usually these statutes, when they're enacted, oftentimes go into effect after a certain date, but this is pending cases as well. So be on the lookout for pending cases. All right, so that's a wrap on the amended Florida Alimony Statute 61.08. We will be doing an updated video soon about how these forms of alimony can either terminate, end, or if they can be modified. So stay tuned for that. If you know anyone who has a pending divorce case and their issues involve alimony, show them this video. They need to know that the alimony law in Florida has recently changed, and have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Do us a favor and like this video, subscribe to the Divorce Broadcast. Thank you, and watch out for that new alimony law.